Welcome everyone to this online mediators ICODR meeting. It's funny, we always do the first Thursday of the month, but it turns out in July, the first Thursday is actually the first day of the month. So welcome to July. And we are delighted to have two of my friends, Tim and Billy, here to present to us about their latest initiatives. Let me tell you a little bit about their background. Willie first, from South Africa. He's a barrister, mediator, and thought leader in the sphere of insurtech. He's worked closely with top insurers and pioneering new ways to settle inter-insurer disputes. And Nuva Law, his company, through their development of online claims resolution technology, Willie's been a driving force in the industry for positive culture change and process improvement. He's very passionate about promoting access to justice and about technology's power to unlock value for organizations within the insurance sector. And let me tell you a little bit about Tim. Tim is a specialist mediator. He's been mediating claims with personal injury, clinical negligence, and commercial lawyers for over 25 years. He chairs the board of Trust Mediation, which is a mediation provider, Claims Portal, which is an online platform for processing high volume of road traffic personal injury claims, and Trust Arbitration, which we're going to talk about today, an online arbitration provider, which is working with Nuva Law. Tim contributes ADR content for the White Book, which is the leading civil procedure guide in England and Wales and other publications. And he was a founding member of the Civil Justice Council. So we are delighted to have the two of you with us here today. And let me hand it over to the two of you to fill us in on the kinds of things you're collaborating on.
Willie, why don't you kick off with a story and I'll join in.
That's fantastic. Colin, you've hit the nail on the head. I mean, I met Tim at the 2016 ODR conference. Graham Ross introduced us to each other because a few years earlier I came to the UK and tried to find out if we do things right in South Africa to compare it to the UK, and I met up with Graham. So Graham was aware of the stuff that we've done in South Africa, which was that we've been working with our Road Accident Fund in South Africa, which is a state-run organization underwriting personal injury claims resulting from motor vehicle accidents. So he introduced the two of us, and we got to have a cup of coffee, and we shared some notes. And one thing that I walked away from there is to realize, look, the UK has got the same problem than South Africa in the way that they deal with these kind of claims. And I need to find a way to go and see what can I do in the UK. It was a challenge. I mean, so as it happened, Nuva Law was formed shortly thereafter as a platform company, looking at how to use the platform economy to get into the space between insurers and claimant law firms. And we were selected to attend the startup bootcamp program in the UK, in London, which we were very fortunate because that allowed us to really interact with insurers, with claimant lawyers, and to understand the real pain points, because that's what this is all about. I always say computers don't solve problems, they mechanize solutions. So if you don't understand the problem, don't try and computerize something because it's not going to help you. You're going to have a 10% efficiency coming out of there. What you really need to understand is what is the problem. So out of that project, we realized that there were three problems that the industry got because of volume. The first problem being, because of the volume, it's difficult to just find each other. You know, there's always a lag in who do I speak to and how do I communicate. The second one is that there's no structure under negotiation. And the third one, if we can't settle, we have to go to court. And then we, out of this, we'll hear into another process, which results in high legal fees and so forth. We got very good traction in the innovation space in the insurance companies. Everybody agreed this is what we need to do. We need to have a structured way in which you can communicate, structured way in you exchange information, and using arbitration as the base to get the final award. So that was the easy bit, to get the innovation guys to understand. However, going down to the dungeons and try and implement something like this it's a different kettle of fish, completely, because then you start to really touch on the operational areas of this. So Nouvel Law has been knocking on the door for the last few years in the UK. During this time, Tim and I continuously work together, exchange notes. Him being at the claims portal obviously helped us a lot in understanding what the bigger problem is. And then COVID came. So I can honestly say we are one of the lucky ones that can say from COVID came something good, because suddenly what happened was that these court dates just piled up. So suddenly an insurance company that had a claim to be resolved, will only be next year. And insurance companies work on reserves. So therefore, if I cannot pay out the claim, it goes to my balance sheet, and therefore it shows up on the negative side of my business opportunity. So the real driver of starting to get success in this field was in fact COVID. I think that you need a crisis to solve a crisis, as I always say. So this is one of those. I think during that time, Tim approached me and said to me that he's had a conversation of two, and is there not something that we can do together? So I'm going to hand over to Tim now and tell us a little bit about that conversation and how that led to what we've achieved so far.
Okay, thanks, Willie. I'll map out my path very briefly as how we got to that conversation, and I think it's really a process of decades of learning that the two really important people are the person making the claim and the person paying the claim. And I think everybody in between needs to recognise the importance of those people. So I had 30 years in litigation. I joined a law firm as a trainee and worked my way through to senior partner, doing insurance and commercial litigation. And after 30 years, decided it was time for a change. By that time, I'd become interested in, as well as litigation, interested in ADR and also technology. And they appeared to be three very disparate things, because although litigation and ADR are supposed to be related, certainly in England, apart from one or two very small sectors, there wasn't a great deal of interest in ADR and mediation in particular, which was what I was interested in. So I had my interest in litigation, my interest in ADR, and an interest in technology, because I'd done quite a bit on technology in my law firm. So I struck out on my own as a mediator, and I formed Trust Mediation, which is a specialist personal injury and clinical negligence, med-mal mediation provider. I then got involved in Claims Portal, and very briefly, that's a volume operation for low-value personal injury claims, which is funded by the insurance industry. And they had a board comprising 6 insurers and 6 what you might call as claimant lawyers or plaintiff attorneys. And they wanted a mediator to keep the peace between them, because they had to run a joint venture instead of fighting each other. So that was an interesting job as a mediator, but it started to bring litigation and ADR and tech together. I think that brings us up to date to about The Hague in 2016, by which time I'd got interested in ODR, because that started to marry ADR and tech. And that's when Graham introduced me to Willie, and we talked about the work that I was doing and the volume claims. Nothing much happened for a while, because the insurance industry very traditional, and they weren't terribly interested in ADR or ODR. They had a portal for claims, and that was basic but satisfactory. Things then move on, and as Willie said, you get to the COVID pandemic, and that certainly intensified interest in online working, as we've all learned. I then got into some discussions commercially about how the motor personal injury claims could be settled more quickly. And that's when we started to look at arbitration being an answer for low value claims. Not my chosen area of mediation, but arbitration, because low value claims need a quick answer. And it was thought that arbitration was more appropriate. But there had to be a platform, which is where I rekindled my my discussions with Willie. We got talking to some major insurers. We got talking to some claimant law firms, and the idea very much appealed to them. So Willie's organisation, Louver Law, and my company, Trust Mediation, got together. We've now spun off a new company, Trust Arbitration, to provide the arbitration side. And we've now got to the stage where we are in very advanced talks with some major insurers and law firms here in England, putting together a project which is very exciting. And Willie, perhaps you can say a bit about the pilots that we've run and what the experience has been like from those.
Yeah, right. So I think the brief that we got from the insurers is give us something that's easy to use, simple, quick, and with quality. That's what they want. The first part of it is, don't give me a system that I have to press many buttons. I mean, claims handlers must be able to use it very easily. And I mean, when it comes to speed, currently it takes us up to 400 days to get a court date, to get a hearing. Speed up that process, please. But we want the same quality as we have in court. So literally it's a project about how do we get a pack of information which is agreed in the protocol in front of an arbitrator, back to the parties on a platform that is easy to use. That was the brief that we got to achieve. So what we did was to develop a very sleek protocol, because that is the agreement between the parties. The protocol is basically a set of rules, and that set of rules we got the parties to agree to, and that also then informed how the system would work. We have processed close to about 200 cases on this platform during the pilot phase. And what we have achieved is basically to bring down the speed of this process down to an average of 3 days, although the protocol allowed for 11. We showed that we can bring down legal costs by up to 50%. And we've shown that the outcome of these awards are absolutely in line with what you would have got in court. So ironically, the same guy you would get, which you would get in court, you got on the platform in a matter of days, as opposed to nearly more than a year in the normal system. The other thing that was quite interesting, that the real trick of this project was to agree between the parties about what it is that you put in front of the arbitrator. What does that pack of documents look like? Because this is how lawyers work. I object. I don't want that document. Please discover that one. Do that. Look, this is who we are. We as lawyers, we are complex beings, and we are trained to be like that. So that is why the view that we're taking is innovation is simplicity that you can get through only through collaboration. You need to get the parties to understand that the importance of simplicity that provides us the upside of this whole process. What is really interesting for us is to see, and we've had these weekly review meetings with the insurer and the claimant law firms, just to see whether there are any issues, whether that is technical on the platform, whether it's the protocol, or whether it's the quality of the arbitrators' awards, is to see how that started to get the parties to collaborate. We are not actually enemies with each other. We are here to provide a service to the claimant, because this whole area is about how do we determine fair compensation to a claimant. That is the real gist of what we do here. Whether we like it or not, it is all about that number, as Tim has said, and what is the best and most cost-effective way to get to that number. Tim.
Let me just butt in there a second. the protocol that you mentioned, I think, was crucially important. And because we got the engagement of the insurers and the law firms, and these were leading players on both sides, we actually established their brief, played back to them what we thought their brief meant, and then got into discussion. Because when we played back what we thought they meant, they said, but we would like this and this. And so we built the protocol on a rolling basis. And as we got new clients in, so we added their ideas into the protocol. And then it didn't stop there, because we were on a pilot. We had these weekly meetings that Willie mentioned. And again, we were listening all around every facet of the service. We were wanting to get feedback. Where do we change? Where are the pain points? What can we do better? What is causing you your problem? And Willie's technical staff in South Africa were in very regular contact with the teams at the end of the phone or an email or on a call like this. And that, I think, has helped us really hone this. And it's taught me that a mistake I made earlier in my career was to sit there and try and invent something and then go and tell people what they were getting. And I found out how wrong that is, and how to engage with the clients, with the customer, and build in what they want. It is a fantastic opportunity to get a service which is really very good, and that's the output we've had from the pilots. The customer satisfaction has really been very high, not only in speed, which is fairly easy for technology to deliver in many ways compared to paper courts and those backlogs, but in the other facets of the service and the quality of the outcomes as well. So I think that's been a real good learning point for us, and that's the way which our joint venture will continue to work.
Well, one of the things that I really enjoyed was we started off with a 4-touch process. Basically, claimant uploads documents. Firstly, claimant log claim. Defendant acknowledged that this claim can be arbitrated. Claimant uploads the documents. Defendant approves that the document is in fact correct, and then it goes to the arbitrator. But then we realized, look, why have a 4-touch one? Let's reduce the touches. So we just took out 1 or 2 of the processes, and we ended up with a two-touch process. I was presenting this solution to another insurer recently, and the comment was, "Do you tell me my claims only have to touch this machine once? Is all they need to do, and they don't have to do anything else?" And I think that's the power of actually working with clients and develop something that's fit for purpose, rather than and I think we've all been through this, that we conceptualize these things in the closed rooms and think we've got all the solutions. But you can only learn from your client, really, what they really need, and then hone a solution fit for purpose for that specific application. I think that's the big lesson that we've learned from those pilots. Yeah, Tim.
Let me say perhaps a little more about the arbitration service, because interested as I am in the tech side of things, clearly this service was only going to be used if the outcomes were such that all of the users had confidence in them. And we were very much aware that there would be detractors from this, that people used to doing things in a traditional way would not necessarily welcome a scheme such as this. And we were ready for the fact that there would be people who would say this was a second-rate justice, or a cheap justice, or dumbed down, or something like that. And so we were very careful about our selection of arbitrators. Our objectives have been these. We wanted outcomes which were impartial and independent, and subject to a quality assurance framework, which again the tech can help with. Also equivalent to current court outcomes, as well as being significantly quicker than the court. And we also set ourselves the objective of being more consistent than the court, which may sound arrogant or cheeky, but in fact, because we are doing all this work on the platform and providing management information back to the customers in accordance with their request and an agreed specification, the outcomes can be scrutinized very, very carefully, one against the other, and head of claim by head of claim. And what that enables us to do is to look at outcomes which may look like outliers. They may appear to be out of step with other, or with the majority or the mean. And we can investigate those and consider, is there a good reason why they're out of step or not? Is there an arbitrator who needs some further attention or training or whatever? And compared to the courts, all the court can do is entertain an appeal. And these are low value claims, usually under £5,000 or £10,000, sometimes more valuable, but they're low value. So the cost of an appeal usually means that it's simply not worth it. And why we think that we can make this assertion that we want to be more consistent with the courts is that by using these tools and having a close-knit party of arbitrators, there can be a continual learning process. And so we were very pleased when the outcome of both pilots we've run, both customers, both on the claimant and the insurer side, affirmed that they were happy with the quality of the arbitrations, and they were very happy that the outcomes were broadly similar to what they got in court. But they're also happy with another thing, which was that during the course of the collaboration, it was found that there were occasionally misunderstandings or mistakes by an arbitrator because there were duplicate claims. Let's say a head of claim which was repeated and appeared to be a duplication and was either disallowed or was duplicated. An ordinary straightforward error by an arbitrator on the papers. And using the Nuva Law platform and the ability to communicate between the parties, we soon established a procedure once one or two of these errors crept in for the parties to say, there is a problem here, can we look at it? And the other party would agree, yes, there appears to be a problem. The arbitrator would review, republish a revised award. No fuss, no appeal problems, no having to go back to court, but simply a few online communications, and matters were resolved. And that's giving a better customer experience, and the kind of customer experience which we're so used to online with so much of the life that we deal with. And that does make the courts and the paper and the backlogs and the delays and the procedure and the rules all stand out in very sharp contrast to what it is we're able to do online. So these are early days for us yet, but there are a fairly high volume of these claims in this jurisdiction, and we look to providing a service which is going to grow quite a bit, we hope, in the coming months and years.
Tim referred to what we call Nuva Notes function. It's a kind of we call it a cheekily legal WhatsApp on the platform itself, allowing for expression. I think so many times, I mean, I've heard the saying, please don't give me another spreadsheet. A lot of these portals got a you fill in numbers and you fill a little thing, a reason in the box. I need to express myself. So on the one hand, it worked very well to channel information back to the arbitrator if there were a problem. But we see this going forward being used a lot more for parties to settle their claims as well. Because one thing that we've seen is from two sides. One, I've already mentioned that the bigger collaboration that happens as a result of what we do had a direct effect, and report back coming back, that we are settling claims a lot easier than we used to, because suddenly you can use, it is the collaboration on one side, but I've got management information that can show me down to a claims handler level, why is a claim not settled? Because you got your last offer and you got your award, and you can compare these two and say, why did this thing went to arbitration in the first instance? And we do see a growth in that kind of collaboration using a more free-flow text environment. And I've been challenging the users to say we're gonna have a competition to develop negotiation emoticons, Brevity is the art of advocacy, they say. So maybe we can put it all in one little smiley face and have an emotion that can settle claims in the future. So that's also a very interesting development for us, and learning from us is just to hear again from your client what it is that they want. And they made mention, in the old days we used to pick up a telephone and phone the other guy and say, hey, come on, just increase your offer. What's the problem here? So having this asynchronous communication and because of the whole world out there sit with their thumbs on cell phones all day long, I think that this kind of technology could well be used in a more free flow of information.
Shall we pause there to see if there are any questions on anything that we?
Sure. Well, I've definitely got some questions I'd like to surface. It's very inspiring to listen to the two of you describe the process you went through and listening to the clients and sort of revising and addressing these pain points. I sort of feel like the two of you are using your mediation skills, in working with the clients to hear what is it that they really want. I think, Tim, a lot of us have that initial inclination of we have to get it perfect so we can go to the client and say, hey, we have this perfect solution for you. But that's unrealistic because it's an iterative process, not only for you building the platform, but also for them to understand what it is that they want. So you modeled that really well. So let me just ask you some specific questions about the platform. First, about neutrals. So how are you finding your arbitrators? Who are on your panel? You said it could be the same people in some cases that you would get if you went to the court. Can you tell me a little more about that?
Sure. We've used, I guess, through mediation, I've got a fairly extensive network in the legal community. And we also have one of my fellow directors of trust mediation also happened to be a part-time judge. So he had a number of colleagues in the same position, and when we kind of gamed how we would respond to second-rate justice, dumbed down, etc., we thought, well, if we have the same people who are deciding these cases anyway,
absolutely,
that's pretty difficult to get by. So we started by casting around and finding, well, who has got judicial experience in dealing with these claims on a recent basis. So that could be part-time judges, it could be retired judges who come down from the bench but are interested in work. And there's a double benefit for us here, because not only are these people actually doing the cases, but they're also very capable of training and mentoring and monitoring. I was
going to ask about that too, yeah.
As we scale up. So we've been very careful to record the learning on this and prepare the training pack so that we're ready to scale as more cases come on. Clearly, there will come a time when we've got to move to people who have not got judicial experience.
Right.
I think by that time we'll have a body of learning and a training program which will bring people on, and we can have team working and so forth. So there is assistance. Again, we've got this ability to use the MI to get very close scrutiny of outcomes, as well as listening to your clients. I mean, it's one thing to go away from court and be chuntering about an appeal and so forth, as many of us have done from time to time. But when you're going to a weekly meeting and listening to what the customers are saying, that's very good feedback, which can instantly go back into the system. So it's going to be a challenge for us to keep the quality up, but we've got experience of our mediation work. We have a government contract with our National Health Service dealing with clinical negligence or the med-mal type claims. And through that, we've needed to establish a quality assurance framework, which is perhaps a bit strange to lawyers. It was certainly strange to me. But we had a business consultant who was done a lot of work on this in industry, and we put that quality assurance framework into the mediation side, and we've transferred it across to arbitration. And again, you don't see anything like that in the courts, because the only remedy is the blunt instrument of an appeal.
Right.
And you may feel vindicated when the Court of Appeal say the judge got it wrong, but it doesn't help a lot by then, because the damage is done. we think that this constant reviewing, constant improvement and monitoring is a way of keeping the quality up and helping us to scale the system. So sorry to be long-winded, Colin, but it's a complicated.
No,
we need to win the confidence of clients.
It's interesting. I think in the States, we're seeing a lot of initiatives from the private sector make their way into the judiciary, because I think, as you say, the judicial system has not been subject to competition in the past. So it doesn't track KPIs. It doesn't have a quality assurance framework. But I think it is very interesting that your consultant said, hey, if you're going to deliver this service, you need to think about this in sort of a customer-centric way. So I think that's an innovation. You know, Willie, you said that you wanted your outcomes to be impartial, equivalent to court, quicker, and more consistent. And I think having the actual people that provide the outcomes in the court be in your platform, I mean, wow, that's no one can argue with that. You know, it's like, hey, it's faster, it's cheaper, we reduce the costs, we're resolving cases in days, not weeks, not months, not years, and it's the same people. I mean, that's a pretty compelling value prop.
Yeah, I have to agree, even if I have to say it myself. You see, I think this is. I've always had this view that the private sector can play a big role when it comes to economic justice. And as I said, I'm very passionate about access to justice, but I do think that one must make a distinction between where it's about a number, where it's economic outcomes, and where social justice and constitutional rights, which clearly don't belong in this realm. But I think the important thing here is I see as a question as well whether a platform like this can be applicable in the US. Now this is all based on agreement. I mean, this is the nice thing about this, and I always explain it to people like that. You know, you've been brought up to think, if I got a dispute, I need to go to a court. I mean, this is the way that I do this. But frankly, if we agree that we're going to have a cake-eating competition to resolve our dispute, we can do so. I mean, that is, we're allowed to do it. That's the freedom of contract. And that's why the protocol becomes so important. So to your answer, is it applicable in the US? Absolutely. Because all we need to get right, firstly, is mediate the protocol. The protocol informs what the system is doing. So it's actually your protocol that the platform is executing. So definitely, if one, and you recall about 2 years ago, I was in LA, and that was exactly what I was trying to establish is the application for these kind of things within the US market. And it remains the same. These kind of claims all got exactly the same characteristics. So what you really need to achieve is get a willing party on both sides to say, okay, let's do this differently. I always loved the law. I never liked the process of the law. I think that's the distinction for me. We apply the legal principles, and you've got quality people to apply it, but there are different ways that I can get the information to you in a structured way, and that they can deliver justice a lot quicker than the current long-winded lawyer-driven process or legal-driven.
Absolutely. I mean, I would go even further than saying, is this applicable to US claims? I think there is a burning need in the United States for a solution like this. You know, we at Modria, we built a system with the American Arbitration Association for resolving medical reimbursement claims in the wake of motor vehicle accidents, which were insurance cases. This is only in New York State. And, you know, we've done a couple million of these cases at this point. And these cases used to take 3 to 5 years in the courts. They take 3 to 5 months in the platform we built with AAA. Now, it sounds like your platform is going to work even faster than that. So every state in the United States has unbelievable volumes of these claims to work through. And I know, Willie, you've been very consistent about this. We were talking about this, you know, 7, 8 years ago. So I know you've been looking at this for a long time. And I think Tim's expertise and connections in the UK, really, that's a key breakthrough. I had another question about sort of the justice component of this, because I do hear criticisms from lawyers and bar associations and law professors about expedited private resolutions in comparison with public, kind of slow, deliberate processes that they argue have a lot of procedural protections. What's the level of transparency for these cases? I know one of the motivations for the use of arbitration is often keeping cases confidential. For the AAA process we built, we do provide redacted awards, full text online, so people can search them. Have you thought about that? I mean, is there going to be a database of these so that like an outside auditor could come in and look and, you know, maybe do a study and establish, yes, in fact, these are equivalent, the outcomes from the arbitrations and the outcomes from the courts? Have you thought about that with your partners?
Well, that's an interesting point, Colin. We've not thought about that exactly, but there is I think, a very basic safeguard here, and that is this is a voluntary system. We're providing MI to the claimant law firms that we're using. The same MI goes across to both parties. And the safeguard is that both parties, both insurers and claimant law firms, can see are the outcomes that we're getting here broadly consistent with the court. And if the answer is yes, they will continue to use the system. If they feel the answer is no, then there comes a time when they say, you know what, we're not going to continue with this. Now, taking the step further that you mentioned, I rather like the idea of the anonymized data being made public. That would be not a decision for us, of course, because the data belongs to the claimants and to the insurer. But if they were to agree to that being made public, that would be another very good way of showing that kind of transparency. So that's food for thought. So, but that's the basic safeguard there is at the moment. It's a completely voluntary process.
Colin, I was talking to one of the clients the other day, and they raised the issue to me and say, you know, can we have a cancellation period for this contract? Because we had it in, say, 6 months or 3 months or whatever the case might be. And we said to him, but you know what? You just reject the next case. You're in charge of this thing. Every case that comes on the platform, you have to agree to use it.
Right.
So if you don't want to use it, then it's just an opt-in. So if you don't want to, just press reject and give a reason why, because I'm happy with the outcomes.
Sure.
But I think the other thing that Tim was raising, and I think we all know that data is something that is going to play a role in the future.
Absolutely.
And one of the things that when we went to Startup Bootcamp in 2017 that we propagated was the whole thing about, number one, this is a win-win-win scenario. I mean, the claimant gets his money. The claimant lawyer who's doing this mostly on contingency can improve his own cash flows because there's a bigger churn. The insurers have got a direct saving in costs, and they've got a better reserve calculation mechanism because they can determine time. However, if you look into the future and you see this as an ecosystem, because this is a closed ecosystem between claimant lawyers and insurers, it's to all their benefit that you start using that data to everybody's advantage. Because what is happening currently, insurers sit with their pocket of data, the claimant lawyers sit with their pocket of data. They've got all their machine learning and AI tools mining this data to give them indicative numbers. But you don't have objective data because it's one side of the coin every time. If you put it all together, one will have better data and better decision support so that people can really get the value of the knowledge out of it. What is this different to your law reports? I've always told people that I'm the first computer when I was still as a barrister. You come into my front door, you ask me a question, I turn around to my books, which is the database of the computer. And I give you a reference as a precedent in the court case, which is why you argue the case in a certain way. So the law is in itself so well positioned to get to that point, if we can do it in a controlled environment and by agreement by all parties in that ecosystem.
Absolutely, absolutely. You know, one of the things you talked about, Willie, was NUVA notes, and you said it gives an opportunity for the parties to express themselves. And I think you talked also about how the process can sort of help cases settle. Can you talk a little bit more about that? You know, I know that both of you have rich mediation backgrounds, and I understand having an arbitration-focused process makes sense from an efficiency perspective. But do you envision that a lot of cases are going to settle on the the steps of the arbitration process? You know, is there a mediation negotiation layer built into the process?
It's the interesting thing about this is if you have 400 days before your case gets heard, you've got lots of time to think. If you know it will be decided upon in 3 days since you press the button, you apply your mind a lot more to the steps of the court has been brought forward right into your face. So definitely we see a role for because you know that the decision will be taken, people will apply their minds, and using Nuva Notes as a mechanism to say, listen, before I press this button, can we have another look at this? And we will the platform will further be developed to allow them also to fill in numbers on the platform. As in, I don't see blind bidding for the moment. I don't think that is what clients want. They want to talk to each other. They want to communicate with each other. I think blind bidding has been with us for how long now?
25 years. Yeah, that's right.
25 years.
Yeah.
But still, there's this need to interact with each other, and ultimately, this is a human process. It's humans sitting on both sides of this of the platform, and they want to express themselves and talk to each other. So the problem with telephones and these kind of things is synchronous. And this way, I can deal with a claim. I can make my comments. I can say, have a look at this, and I can go on to my next one. And ping on the other side. My WhatsApp arrives. So I do think that that kind of communication is something that can grow.
Willie, let me just jump in and have another perspective on that, if I may. We're responding, Colin, to the process that exists in England at the moment. I've been a great admirer of the work of Shannon Salter in British Columbia, and I know that in some of their work types, they're getting about 2% of the initial inquiries are turning out to be arbitrations, because they're getting settled beforehand with Solution Explorer and so forth. That's not the mindset in this jurisdiction at the moment. And the insurer claimant law firm is, we exchange offers, we reach dispute, and we want a result. And certainly in the low value claims, that is the thinking. But I believe this process will change that, and I believe that we will be able to build in to the Nuva Law platform the discussion period, perhaps assisted discussion, perhaps other ODR tools we can bring in due course. But I certainly see a discussion phase and perhaps a facilitated negotiation using some of the approach of British Columbia, and I think people will get used to that. Certainly, I think the MI is already producing some interesting responses from insurers and claimant law firms, because they're starting to ask the question in our weekly meetings. So we keep losing these ones. So why do we do that? Well, that's a loop which kind of takes you back into the discussion, and perhaps there are certain claims that they should be discussing. So the answer to your question is no at the moment. It's a dispute arbitration, but I think the platform will become richer and build back into the negotiation phase.
Well, I do want to open it up to our attendees to ask some questions. So if anybody has a question, please don't hesitate to put it in the chat or to raise your hand in Zoom. But I did want to say, you know, I think we do sometimes elevate mutually agreed upon resolutions like mediation outcomes over evaluative outcomes, I think, in the field. And I think that that's short-sighted. I really think that evaluative mechanisms and facilitative mechanisms need each other, you know, and I think that if people know that they can come in and they can get a final determination, there are a lot of cases where that's what the parties want. And if you put them into a conversation and you're just going around the mulberry bush saying, you know, can we find an agreement? Can we find an agreement? People get frustrated. So I think that I think it's great to focus on an evaluative outcome and then introduce as part of the process, hey, do you want to, you know, use this, you know, what do you think? I mean, what do you think your case is worth? Willie, it was interesting. I felt like we did talk about blind bidding, and because there were a lot of blind bidding. I mean, Cyber Settle focused on insurance cases and Click and Settle focused on insurance cases, but there was big pushback from the insurance companies, because I think the adjusters who were handling these cases felt that those very simple algorithmic models sort of oversimplified the complexity of what they were doing, which is really understanding the human journey and needs in trying to find a resolution that works, as opposed to just averaging two numbers and saying, okay, this is what we're going to come up with. But I know, Tim, before you were talking about data, and there's a lot of value that can come out of this. I mean, as you resolve these cases, you're going to have a sense of what these cases are kind of worth. And I remember the Click and Settle platform, when you came in and you explained what issue you had, it would sort of give you the ZOPA. It would say, this is probably where your case is going to end up. And the technology wouldn't, I mean, it's just advisory. It was just maybe a bell curve to say, you know, here are other cases just like this. These are the resolutions achieved. But that can really provide a huge incentive for people to work it out, because now they have data they didn't have before. So I think the algorithmic role may evolve over time, even though you're starting with really high quality arbitrators deciding these cases. I wouldn't be surprised if the pre-arbitration process gets richer as you get more data.
Yeah, I agree with that, Colin. I also think there's another way this is going to grow, because the customers, the clients, been very interesting. Once we show that online arbitration works for quantum-only claims, then they're saying, well, will this work for liability? So it's yes. It's my belief and hope that when this gets running in a way that it will be doing in a few months' time, the next question will be, well, can this deal with higher value claims? Which the answer is yes. But at that stage, we may be saying, well, when you reach dispute, do you prefer to go to arbitration or mediation? And then we give the option, because when we go up the value chain, there may be people are prepared to say, you know what, we'd quite like to mediate this claim and to try that. And sure. Because the people we mediate with now are so used to working online, I can see this being acceptable in a way it simply wouldn't have been a couple of years ago.
Right, I completely agree.
Colin, I would like to make a comment on something that we're busy working on now, which I really find fascinating. As Tim was saying, currently we're dealing with quantum claims only on the papers. So the question came up, how do you deal with liability? So liability, as we know, and we've all seen the court, how you do it, you call the witness, you say, you've driven through a red robot, he says no, you say, here's a photograph, he still says no, and then the judge needs to make up his mind whether he believes the guy or not. So the whole notion of cross-examination is a big thing. So what we've done is we said, no, that's not necessary. I mean, why do that? So in liability claims, and something that we're going to test now is, let's upload all your information, your videos, all the different data that you can put in front of from the arbitrator. Instead of cross-examination, you ask the arbitrator to ask questions and clarification through the Nuva notes.
Interesting.
So instead of, and because this is all about scheduling, how do I get the arbitrator, two representatives, and the witnesses all in one Zoom call? If the other way around, it's a more of a asynchronous process, but you can also use technology to push down a question straight down through a WhatsApp to a guy that sits behind his desk and ask a question and clarification. So that kind of innovation in rethinking the legal process of, do we really need cross-examination? I mean, that's the question. It's something that we want to test. Because so now we're really getting down to not the computer solving the problem, but it's the innovation and the rethinking of how we used to do it and what you can do through the use of technology, which is a very interesting way of looking at this.
Well, this really takes me back to Nuva law. You know, it really is rethinking the justice process front to back. If we were to take components from the existing justice system and put them into a new system, what would we take and what can we leave behind? I think there's a lot of research that shows that people think they're a lot better at evaluating the trust of testimony than they actually are. You know, it's pretty easy to manipulate someone. So what I'm gleaning is this is a documents only process. It's asynchronous. You don't have video built into the platform. Are there any cases where it could be requested from the parties that a witness be deposed via video, or what are the provisions for that kind of thing?
Yeah,
so
obviously you go.
You go.
You know, from a platform platform perspective, obviously these kind of things will be integrated into the platform, that you can have video calls, you can schedule calls, and all these things will be built in. But that's on request by the parties.
I see.
And
Kind of on an
just
ad
to
hoc
that,
basis.
Colin, the reason it is on request is that the claims we're dealing with at the moment are in the lower value, and so it's more difficult to justify the cost of a synchronous live hearing and the scheduling problems.
Sure.
However, some of these claims are in fact proxy claims, because you get a motor accident and you get a small personal injury claim is made. It may be that there's a large vehicle damage claim or an even bigger personal injury claim sitting in the background.
I see.
And so often the small claim will go to the court for a decision, or in this case to arbitration, and that liability decision is then used for the other cases. Now, if there are large value cases sitting behind this small claim, it may be the parties want to examine liability in more detail, and our arbitrators are already in their judicial capacity hearing cases online. So we've made it clear that on request, we're perfectly willing to set up an online hearing, and if they want a full day's hearing in the usual way, that can be provided for in front of the arbitrator online. And there's been some interest shown in this, but I think that will come later on with the higher value claims. At the moment, it is papers only to fit with the efficiency requirements of the values of the claim.
Absolutely. Well, we always say fit the forum to the fuss, but by having those as an option, I think you could definitely handle higher value claims where people are going to want those. Well, let me just ask some more specific questions, and then again, I want to open it up to our attendees to see if they have any questions. How does the money work? You know, who is paying you? How much are you paying the neutrals? I don't want to get too grubby about it, but we have a lot of people on the call that are setting up their own systems. So we're trying to figure out how sustainability works. Is it? I know it's only a pilot phase, so some of those questions may be unresolved. But can you answer essentially how it operates on a cost basis?
Well, essentially, these claims at the moment are claims where if they went through the court and a liability were established, then the insurer would be paying for the legal fees. So in the first part of the pilot, that's been fairly easy. So the insurer pays. Coming on to the next wave of claims we're looking at, the fee structure is a little more complicated, and it depends upon the court fees. So essentially, the benchmark there is who is going to end up paying the court fees. And if the claim goes the claimant's way, the insurer pays. So essentially, at the moment, the insurer is funding the program. As we move forward, there will be claims where the claimant has to be responsible for the fee.
Sure. I sort of feel. Yeah, please.
Which in itself is a good one. You don't want a free service, do you? No. Because it also applies and help people to think through: do I have a case or not? And not just because otherwise you will get just multiple of claims being put in that don't have any merit in it. So
that's true. You want people to have a little skin in the game. I will say one of CyberSettle's big issues was the perception was that CyberSettle was owned by the insurance companies because they accepted investment money from a big reinsurance company, and the fees were initially paid by the insurers. So eventually they got to the point where it was essentially free to start, very low fee from each side, and then they took a portion of the settlement, which had its own issues. But there may be some perception issues on the part of the plaintiff's attorneys if they feel that well, hey, wait a minute, all the costs are being paid for by the insurance company, and you have an incentive to keep them happy. So that's another good reason to engage plaintiffs' representatives and trial lawyers, early and often in the process to make sure that they feel like their voices are heard.
Yeah, sure.
Absolutely. Independent and impartiality is key to this.
Absolutely.
We say trust is built into the system.
That's good. I like that. The other thing that I wanted to say is, if you did want to bring this to the United States, are you looking for partners? I mean, you've got some great people here on this call who are very experienced. I'm sure they're thinking, this is an interesting model. What could we do to bring this to some of these American insurance cases? So maybe you can speak to that.
I think my answer to that, Colin, is that we're always up for a cup of coffee. A virtual cup of coffee is a good way of starting a conversation. It's how Willie and I started a conversation.
That's right. Strong Dutch coffee. Well, maybe a pint is a better way to do it too. I don't know. Whatever beverage is appropriate at the time zone.
A Heineken or something like that.
Yeah.
Yeah. Seriously, we've got our hands full at the moment, getting this moving. But there will come a time when we want to look further, because, as I said earlier on, the really important people here are the person making the claim and the person paying the claim.
Absolutely.
And this is a way of putting them together through ODR, as we're all aware. And this is a model which can work, and I believe it applies across jurisdictions. It's as applicable generally as ODR is.
Oh, no question.
Yeah.
It's a $1 billion space. There's no question about that. Somebody just needs to crack the nut. So, Willie, what were you going to say?
No, all I can say is I said a little bit earlier that Nouveau Law believes that innovation is simplicity that we only can achieve through collaboration.
Mm-hmm.
So our DNA is collaboration. I think that is the way forward, and it's the only way that one could learn from what is needed in the US itself, because I think that is the learning curve I've gone through, being a South African, coming to the UK. And understanding that I don't know my way around London. I need Tim to help me to see what can be done, and through that we came up with a very, very nice solution. So I'm pretty sure by doing exactly the same module and going through that exercise, we will find a model that will work in the US, and particularly in a state, because that's the one thing that I found when I was there. Mm-hmm. Is you guys are many states and many countries.
Oh yeah.
So if you move from state to state, it looks different, and therefore it's very necessary to have local partners in these ventures.
That's absolutely true. Yeah, I mean, we talk about United States and England, but it's more like the United States and the EU. We have our own states, our own systems, our own crazy patchwork of laws that have to be navigated, particularly in the legal context. So, well, and the other thing Shannon Salter is amazing about, every time I see her, she always hammers home human-centered design. You've got to listen to your users. You can't presume you have all the answers. And I hear that loud and clear from the two of you. And to me, that's the key determinant of success. How humble can you be in listening to your users and figuring out what their pain points are? Because if you come in and you say, well, I know what you need this, that, and the other thing, do you really know their business as well as they know it? Probably not, so yeah. I think that's great. Well, I'm very, very excited about this initiative. I'm very confident in its success. So hopefully some of the folks on this call are going to take you up on that offer of a coffee, and we can figure out how to get that to the US. I don't know if your Los Angeles partners are out of the picture, Willie, but maybe there's some others, and that's only California. As you said, we have 50 different states, so maybe there's a lot of people within ICODR that might be interested in collaborating. Yeah. So any other closing thoughts? Or please, Billy, what were you going to say?
No. All I said, I missed out on coming to visit you, Colin. So next time, hopefully.
That's right. You sent one of your folks to come be in our office. We had a wonderful time with that. But fortunately, ODR is not going anywhere. That's one of the great things. Ethan Katch has said this several times about ODR. The good thing about being in the dispute industry is we're never going to be out of work. There will always be more disputes. So we don't need to worry about the need disappearing. So with that, and I see Stan said this was such an important information session. I know the direction my skills can be more valuable. Thank you so much. So this was a great, great session. We really appreciate the two of you taking the time, and we will stay tuned for more updates on your successful milestones as you pass them. So thank you, Tim. Thank you, Willie, for a great session. If we could give them a little round of virtual Zoom applause, that would be much appreciated. Much appreciated.
Thank you for having us. Thank you.
Thank you so much.